I'm Father Bill Daly, a Holy Cross priest. I teach in the law school here at Notre Dame, and I'm a fellow at the Center for Ethics and Culture. It's a pleasure to be with you this morning for our panel on justice and religious liberty. Some of you may have heard that there's a lawsuit going on that involves this university and religious liberty. We may hear some thoughts about that today. I would be interested too myself. That lawsuit involves, as it happens, the background of the Affordable Care Act, alternatively called Obamacare, sometimes by the president himself. And we learned this morning from the National Journal that they were holding back on the controversial regulations under Obamacare, and now that the election is safely in hand, we have more regulations to look forward to, according to the National Journal. So maybe we'll convene back here in a couple of weeks and get further thoughts from our panelists on that. No further ado, I will introduce our panelists who will speak in the order extending away from me. So we'll begin with my great friend and a Notre Dame graduate, Professor Michael Moreland, Vice Dean of the Villanova Law School. Professor Moreland received his BA in philosophy from the University of Notre Dame, his MA and PhD in theological ethics from Boston College, and his JD from the University of Michigan Law School, for which, in great misericordiae, we forgive him and do not seek justice. At Villanova, Professor Moreland teaches torts, evidence, bioethics, and the law, advanced torts, which I understand he likes to call AP torts, which would be funny to nerds in law school. I think it's funny. Justice and rights, and seminars in bioethics and Catholic social thought. In his practical experience, Professor Moreland clerked for the Honorable Paul Kelly of the 10th Circuit Court of Appeals. He was an associate at the Williams & Connolly firm in Washington, D.C., where he represented clients in First Amendment professional liability and products liability matters. Before coming to Villanova, Michael served as the Associate Director of Domestic Policy at the White House, where he worked on a range of legal policy issues, including criminal justice, immigration, civil rights, and liability reform. Professor Paul Horwitz of the University of Alabama School of Law. Again, no comments relating to football programs. We'll settle that on the field in Miami. Professor Horwitz teaches law and religion, constitutional law, and the legal profession. He received his BA in English literature from McGill University in Montreal, his master's with honors in journalism from Columbia University, his LLB from the University of Toronto, where he was co-editor-in-chief of the University of Toronto Faculty of Law Review. That's a great title. And his LLM, his master's in law from Columbia Law School in 1997. Professor Horwitz clerked for the Honorable Ed Carnes of the U.S. Court of Appeals for the 11th Circuit. Before joining the University of Alabama faculty, Professor Horwitz was an associate professor at Southwestern University School of Law in Los Angeles. He has visited as a professor at Iowa, San Diego, and here at Notre Dame. In addition to having written and spoken widely on issues in constitutional law, Professor Horwitz is a member of the popular legal blog, Prof's Blog, which leads us to our final speaker, his colleague at Prof's Blog, Dean Rick Garnett, Associate Dean of the Notre Dame Law School for Faculty Research and Professor of Law, Concurrent Professor of Political Science. Professor Garnett teaches and writes about freedoms of speech, association, and religion, and also about constitutional law more generally. He is a leading authority on questions and debates regarding the role of religious believers and beliefs in politics and society. He has published widely on these matters and is the author of dozens of law review articles and book chapters. Rick is a graduate of the Yale Law School, which again, we try not to hold against him around here, because somewhere along the line he picked up knowledge of the law as well. It may be when he was clerking for the late Chief Judge of the 8th Circuit, Richard Arnold, or perhaps for the late Chief Justice, William Rehnquist. And Rick has the following feature that distinguishes him very much from me, his extremely junior colleague. I would try really hard to write something that would appear in the Yale Law Review, and they might send it back saying, why don't you send this to USA Today? Rick, who publishes regularly in the elite law reviews, is also able to translate his works for us to read in the USA Today, where he is also widely published and helps to educate the public more broadly. With that, Professor Moreland.
Thank you, Bill. It's a great honor to be here. I thank Carter Snead for the invitation to participate. and to be alongside my friends Paul Horwitz and my co-Mirror of Justice blogger. Rick actually wears two blogging hats, Prosblog and Mirror of Justice, where both of us blog on topics related to Catholic legal theory, and also Lisa Schultz, who is in the audience. So my topic, my remarks are titled Religious Freedom, Justice or Toleration. I think we are apt to suppose that problems of religious freedom are problems in the end about toleration in its modern sense and toleration's limits. That is, there are all sorts of beliefs and practices we might reject as somehow wrong, but we tolerate them all the same. And so conflicts over religious freedom frequently pose a question about the limits of such toleration. And so you can think about a whole range of examples, many of them in the news these days, about religious freedom, and think about how they raise questions involving toleration. So as Father Daly mentioned, the contraceptive mandate from the Department of Health and Human Services can be framed, at least in part, as a question over whether or not the state will or will not tolerate the refusal of religious institutions to cover contraceptive benefits for their employees in their health insurance plans. Other examples from the last decade or two of case law and religious free exercise, cases involving police officer clean-shaven requirements and whether or not Sikh and Muslim police officers are entitled to be exempt from those requirements. And the question there, of course, is will the police department tolerate non-compliance in those instances with its uniform requirements? Refusal is another issue very prominent in the contemporary media. The refusals to participate in same-sex marriage ceremonies, a case actually that's going up before the New Mexico Supreme Court soon on the question of whether or not a husband and wife photography business could refuse to be wedding photographers for a same-sex civil commitment ceremony. Parental decisions about treatment of minor children, a topic that frequently comes up in the context of Christian Scientists and Jehovah's Witnesses, whether or not the state will tolerate decisions that jeopardize the health of minor children. And so in each of these situations, one of the central questions is whether to tolerate, most often legally by legislative or administrative exemption or through litigation, such practices. But in these remarks, I want to step back a little bit from the sort of the very contemporary questions that I've mentioned and the fights that many of us engage in legislative, administrative agency and courts, and ask about what justification we have for tolerance in the first place. More specifically, in light of the topic for this conference, what is the relation between toleration and justice? Bernard Williams, the late English philosopher, once noted in I think somewhat unduly neglected paper about 15 years ago, that we can think about tolerance on at least three levels. So there are practices of toleration, right? There's the putting up with, the suffering in the old-fashioned sense, the existence of other groups and practices of members that we don't agree with. And you can multiply the examples ever more in a society as pluralistic and diverse as our own. So those are the practices of toleration that we exhibit and we see in our contemporary political society. And then these practices of toleration, as Williams noted, depend in some way on attitudes of toleration, dispositions that encourage people and groups of people to be tolerant toward those with whom they disagree and to suffer those disagreements and to allow beliefs and practices to flourish with which one disagrees within certain limits. But then finally, and this Williams, I think, quite astutely observed is the most difficult of all questions, there's a virtue of toleration, or toleration as somehow a strong normative value that underlies those attitudes of toleration that in turn dispose one toward practices of toleration. Now, to be sure, we inhabit a political society today that more or less exhibits practices of toleration, with perhaps exhibiting some increasing contentiousness of late about its limits. And there are widespread shared attitudes of toleration. You can look at the, for instance, the Putnam and Campbell book about sort of the widespread views that Americans exhibit about toleration of non-co-religionists or those of no religious faith. But what of the virtue of toleration? Why is toleration valuable in the first place? That, as Williams noted, is a much more difficult and perhaps impossible question. So I think our culture is good at fostering the practices and attitudes associated with toleration, but I am less sure we have a strong sense of why toleration is important in the first place. My provisional thesis here is that I think part of the cause of the seeming intractability of many contemporary problems involving religious freedom in the United States, though elsewhere as well, is that we have a difficult time discerning the meaning, justification, and limits of toleration when we lack an adequate account of justice. Where we lack an adequate account of justice, toleration will come to be thinned out. Toleration requires a rich framework of justice, and the virtue of toleration makes sense only within the context of the virtue of justice, and it is precisely because we lack such a virtue, at least in any kind of robust conceptual understanding, that toleration comes to be seen as more and more contested. So we've inherited a moral vocabulary of toleration that has echoes, as you know, far back in the Edict of Milan and in Augustine, in Nicholas of Cusa, in Spinoza, in Locke, and in Mill, but we lack the necessary context to give meaning to that vocabulary. The lack of an adequate virtue of toleration, in turn, runs the danger of leading to a certain kind of indifference. As Williams noted in that paper I mentioned earlier, historical responses to religious pluralism in the modern era have either been skeptical of the view that there was no truth, or at least no truth discoverable by human beings, about the validity of one church's creed as opposed to another's, or more generously, the more generous attitude was one of a certain kind of ecumenism. God did not mind how people worshiped so long as they did so in good faith within certain broad Christian limits, at least in the initial modern understanding, and someone like Locke, eventually leading beyond Christianity, of course, to other religious faiths. But over time, these attitudes probably lead to a form of indifference. If you don't care all that much what anyone believes, as Williams says, you do not need the attitude of toleration any more than you need the attitude of toleration with regard to people's tastes in food. And so we need principles of toleration to come from some conception of justice. And with that, I think we have before us some alternatives in the contemporary literature, but that I think pose certain problems of their own. So two of the more prominent, as many of you know, are the view of toleration as based in a certain kind of respect for persons, as articulated in John Rawls' book, A Theory of Justice, and somewhat more elaborately in later works of his, and toleration based in autonomy, which is a view closely associated with the legal philosopher Joseph Raz. So for Rawls, he argues in A Theory of Justice that we would not know in the original position what religious views we will hold, and so toleration is required by the first principle of justice in the equality of basic liberties and respect for persons. As Rawls says, and here I'm quoting from Theory of Justice, the parties in the original position must choose principles that secure the integrity of their religious and moral freedom. They do not know, of course, what their religious or moral convictions are, or what is the particular content of their moral religious obligations as they interpret them. They do not know how their religious or moral view will fare in the society, whether, for example, it's in the majority or the minority. Equal liberty of conscience, he argues, is the only principle that the persons in the original position can acknowledge. They cannot take chances with their liberty by permitting the dominant religious or moral doctrine to persecute or to suppress others if it wishes. Even granting that it is more probable that one will not turn out to belong in the majority, to gamble in this way, Rawls says, and would show that one did not take one's religious or moral convictions seriously, or highly value the liberty to examine one's beliefs. Rawls, in other words, argues that to the extent one thinks one's religious views really are valuable, you will more and more strongly hold to some kind of principle of tolerance because you wouldn't want to gamble on those, on your religious views being coerced or suppressed. And so for Rawls, religious toleration is the key to adjudicating all moral disputes in liberalism. This idea, he says, which arose historically with religious toleration can be extended to other instances. Thus, we can suppose that the persons in the original position know that they have moral convictions, although, as the veil of ignorance requires, they do not know what those convictions are. In this way, the principles of justice can adjudicate between opposing moralities, just as they regulate the claims of rival religions. And so thus Rawls. Joseph Raz takes a view, as I say, that's somewhat related, although more robustly developed in some papers, that talks about the importance of autonomy in safeguarding a principle of toleration. For Raz, an autonomy valuing pluralistic morality requires a principle of autonomy which will protect people pursuing different styles of life and assure the survival of the options to pursue different forms of life. As Raz writes, the principle of autonomy itself generates such a principle of toleration. It turns out that the boundaries of the autonomy-based toleration are those stated by the harm principle. So toleration is required by autonomy, and then the limits of toleration we get from a Millian harm principle. It allows perfectionist policies so long as they do not require a resort to coercion, because both coercion and manipulation invade autonomy, and a morality which values autonomy highly will shun either, except where they are required to protect autonomy. So we have at least two views of toleration on offer in liberalism, the Rawlsian respect for persons view and the Razian autonomy view. Alongside that, though, we might argue that there's another way to connect toleration or to drive toleration from an account of justice, one that would emphasize more the, at least in the Catholic tradition, a certain kind of account of justice that would place, for instance, emphasis on the common good of all seeking truth, and especially truth about God, usually in communities of worship and prayer. And so one holds two claims, the truth of my religion, but tolerance for others, because it is to the common good that all be allowed to pursue God in their own conscience. And you see at least one articulation of this, I think, in the Second Vatican Council's declaration on religious freedom, Dignitatis Humanae. As Dignitatis Humanae argues, we perceive and acknowledge the imperative of the divine law through the mediation of conscience. And I'm quoting here, in all his activity, a man is bound to follow his conscience in order that he may come to God, the end and purpose of his life. It follows that he is not to be forced to act in a manner contrary to his conscience. There is a further consideration. The religious acts whereby men in private and in public and out of a sense of personal conviction direct their lives to God transcend by this very nature the order of terrestrial and temporal affairs. Government, therefore, ought indeed to take account of the religious life of the citizenry and show it favor, since the function of the government is to make provision for the common welfare. So also with regard to this richer account of justice and its connection to toleration in the Catholic tradition, I think a view of the freedom of the church. So the first, all these arguments thus far are really about toleration insofar as it relates to, at least for the most part, individual toleration, the rights of individuals in their beliefs and practices and tolerating them even where one disagrees, but also the freedom of the church, that determinate forms of community, determinate forms of the ecclesia are necessary for justice on this account. Jurisdictional differentiation between the ecclesia and the state come down to two forms of authority, neither intruding upon the other or exceeding its proper bounds in a system of ordered liberty toward justice. As Alistair MacIntyre, in Whose Justice, Which Rationality, summarizes an account associated with Pope Gregory XVI, libertas, therefore, libertas of the Church, is a condition of justitia, and when both political societies and the Church are ordered in accordance with justice, the appropriate libertas of each will also have been achieved. So we have at least two or maybe three conceptions of justice corresponding to at least two, or of toleration, sorry, corresponding to at least two or maybe three conceptions of justice. And so the or in my title, justice or toleration, is not so much meant to denote opposition as much as it's meant to denote a certain kind of lexical priority between justice and toleration. For Rawls, and I think for Raz, toleration it comes into consideration right at the outset of how we think about justice. That it's right at the center of how one understands the principles of justice in a liberal state, that there be toleration. The alternative account, and one that I think is much underdeveloped, is a view of toleration as derived from justice in a second or third order way. Toleration as a necessary aspect of general justice, insofar as toleration is ordered to the common good, and toleration also as an aspect of commutative justice, not on account of any exchange that takes place between those being tolerated and the tolerators, but on account of the fact that each one of us owes to another toleration because of the right to religious freedom enjoyed by every person, and also that the state and the state's authorities owe to its citizens the recognition of their rights to religious freedom individually and institutionally. So the difference is between toleration as a first word, as in Rawls and perhaps Raz, versus toleration as a second or third word. And associated with this is a whole set, and I won't spend much time on this point, a whole set, I think, of competing epistemological claims. So for Rawls and Raz, very much so, there's this fact of pluralism. And because of this, we conclude that we can't know the truth in religious doctrine, and so we must be tolerant of a wide range of religious views. I think the alternative account, at least epistemologically in a sense, is that we can know what is true in religious doctrine, if only with great difficulty and admixture of error, as St. Thomas says. But it would be unjust. It would be contrary to practical reason and to the common good to coerce in matters of faith absent, as the tradition has long argued, threat to public order, including public morality. I think our problem is that the first view, the liberal Rawls-Razian view, has come to dominate and crowd out the second, both in political theory and in this kind of, as I say, sort of epistemological manner. And you see this, for instance, in the way in which we account for limits to toleration, which, of course, is what many of these struggles about religious freedom are all about. So for the liberal tradition, very much so, Mill's harm principle, and this is expressed in Raz's view, comes to be the dominant way of understanding the limit on toleration. But as many have argued, most recently one of our colleagues in the law and religion field, Stephen Smith from San Diego, in his book on the disenchantment of secular discourse, there's a danger of emptiness in that regard. It's hard to see from the perspective of the harm principle what the baseline from harm should be without smuggling in non-Millian illiberal premises into the argument. And but for the alternative tradition, there is a limit in public order and public morality as articulated, say, for example, in the way in which positive law is derived from natural law. And so we have before us a whole range of options for thinking about toleration and justice, a respect for persons and autonomy view. I should say there's also another view, a kind of modus vivendi view that I haven't explored much here that's associated with Hobbes. And I think a richer, more theologically grounded, and at least in the Catholic tradition, a more historically present account with regard to the relation of toleration and justice. So when we come to make law, a great deal will turn on how we come to think that toleration is required in the first place. Do we think toleration is part of perfecting the common good, or is toleration a mere modus vivendi based in respect for persons and for autonomy? I think that one manifestation of this problem is the peculiar way in which much of liberalism has come to struggle with issues of toleration. So the central questions become, should we tolerate the intolerant? Or worries that you encounter in the literature frequently about children in repressive environments. Joel Feinberg, the famous liberal philosopher's set of arguments about children's right to an open future and intolerance for intolerant groups that repress children in ways that inhibit their, as Feinberg articulated, right to an open future. But I think the problem then is that we can't really talk meaningfully about tolerance when those are the only options on the table. And so I think religious freedom is a site of particular controversy now for many contingent political reasons. But I also think we no longer have an adequate account of how toleration relates to justice, and that is fueling much of the problem and the contentiousness and the seeming intractability of the debate. And so while much of the time we think about toleration and its limits, we also have to think very hard and robustly about justice. And that's what the rest of the conference is all about. Thank you.
Thank you very much. Can you all hear me okay? Good. All right, well, I'm thrilled to be here. As was said, I had the opportunity to teach at Notre Dame a few years ago. Very much enjoyed being part of the community here, and I'm always happy to get a chance to come back, especially if it's not in the winter. At a multidisciplinary conference like this one, I see it as the role of the academic lawyer to leaven the proceedings a little bit by saying something that manages to be both mostly clear and mostly banal, and I'm going to try to do just that. And before I do, I want to say something about my background. It seems appropriate given some of what I'll have to say today. So I should say I'm not in the Catholic fold. I do write a lot about law and religion issues, and specifically recently I've been writing a lot about the role of various non-state institutions, including religious institutions, within the First Amendment. I have a book coming out in the next little while called First Amendment Institutions. Incidentally, makes a lovely Christmas gift. But for a variety of reasons, not least that my wife is Catholic and I get dragged to a lot of masses, I often write about and around the church and its issues. I keep trying to get on Rick's Catholic legal blog, but he keeps denying me. So there's going to be a perhaps unusually intimate perspective about the church or attachment to the church in this talk, even though I am an outsider. And I try when I do this to approach things simultaneously from a sympathetic internal perspective and a more clinical outside perspective, while trying to remain humbly aware that I'm not genuinely offering an internal perspective. So if I'm not of the faith, but hopefully what I say here will be offered in good faith. So let me summarize. I'll say 4 things today. First, part of a just social order, in my view, includes recognizing the central role that institutions, including churches, play in the infrastructure of our society, and recognizing the limits of the law in regulating and adjudicating with respect to those institutions' central obligations, recognizing, in other words, some form of church autonomy. Second, we should appreciate that this point, this first point, is a contested and reasonably contestable one. It's less clear to me that justice absolutely requires this approach, and even if it does, there can be reasonable disagreement by just people about how to implement it. Third, making a statement about the constitutional and social value or even necessity of some form of institutional autonomy for some central institutions, including churches, is not the end of the discussion about what justice requires in this area, but rather is just a beginning. Most of what it's important to say about justice in this area will not be about what churches are free to do, it will be about how they do it. It will require significant and public discussion, both from within the institution and beyond it, about what it means for an autonomous institution, including a church, to act justly toward its own leaders, members, and employees, as well as others. And fourth, these points may actually say something important about why, in the words of one writer, the Fortnight for Freedom was a bit of a flop, quoting her, I should say so. I don't mean that as a criticism of the aims of the church's recent statement on religious liberty or its opposition to the contraception mandate. Rather, I mean that public arguments for institutional autonomy, including those recently made by the church, might be more effective, more persuasive, if they were as much about self-criticism, about the obligations of an institution, how that institution sometimes fails at its obligations, and what it ought to do about it, as they were about the underlying goal itself. So, let me begin with a recent case called Hosanna Tabor Evangelical Lutheran Church and School versus Equal Employment Opportunity Commission. Everybody familiar with it? Good, then I can just skip to part 2. Let me say a word about it. This involves a so-called called teacher in an evangelical Lutheran school. Her duties are not much different from those of lay teachers, but she's clearly gone through a religious process to achieve this position. And she develops narcolepsy. She goes on leave. She's ready to come back, and the school says, Well, first of all, the substitute teacher has formed an attachment with the students, and second, we're not sure you're ready to come back, so let's think about it. They offer her ultimately, basically they say, we'll pay some of your premiums on an ongoing basis if you'll resign as a called teacher. She says no. She shows up for work, and they tell her, we're going to be dismissing you. She tells them, I have legal rights here, I've obtained counsel, I'm looking at my possible ability to sue for employment discrimination. And you're protected in invoking those legal rights against retaliation, against being fired for saying that you have rights or for suing. And the church says that has irreparably damaged our relationship. This is another reason that we can no longer continue with you. She sues, and the case reaches the Supreme Court, and it decides in Hosanna Tabor's favor that her suit cannot proceed. Now, if she had been an auto mechanic, the outcome of the case would have been pretty easy, I think. She would have won. So why dismiss it here? The legal answer is that it's required by both the Free Exercise Clause and Establishment Clause of the First Amendment. The law cannot interfere with the internal affairs of a church, cannot regulate whom the church chooses to serve as one of its voices or leaders. To do so would involve the courts in the kinds of questions about religious doctrine that they're not competent to decide and not allowed to decide. It would interfere with the church's free exercise of religion, therefore, and would also arguably risk an establishment of religion. So we get the so-called ministerial exception, the idea that church decisions with respect to what we call ministerial employees are not subject to the usual operation of the laws governing employment discrimination, even where the church's own doctrines don't require or even permit those forms of discrimination. I think that decision was quite right, and that's not just because a contrary decision would arguably have involved issues beyond the court's competence. It would also have involved questions beyond the proper scope of the court's authority. Hosanna Tabor is right not just for practical reasons. More than that, it is arguably a necessity in a just constitutional order, in a just social order. So think of our social order as an infrastructure. The infrastructure is not erected solely around the state, with the state and its courts as the central or primary institution and everything else subordinate to it. Rather, ours is a society of societies, one in which a variety of institutions, including but not limited to the state, all play vital roles in giving meaning to individual and communal life, in serving as counterweights to the state, and in creating a whole and complete society. The state may, and probably must, play some regulatory role even here. But our primary focus should be on self-regulation and not on top-down, generally applicable regulation by the state and the courts. Church autonomy isn't just good for the church. It, and some degree of autonomy for, in my view, other institutions, is necessary to build a just social order that's not narrowly focused on the state itself. Now, as strongly as I believe that first point, I want to say second that at least some aspects of this idea are rightly contestable, and many aspects of its application will be subject to reasonable disagreement. First, it suggests many difficult questions of implementation. Who is a ministerial employee? Obviously, it includes a priest, a rabbi, an imam. Does it include a church organist? Does it include a church janitor? Does it include a called teacher whose duties are not substantially different from those of a lay teacher? Does the ministerial exception apply not only to religious discrimination in employment, but also to discrimination on the basis of race, where a church's own doctrines oppose racial discrimination? Does it apply even to claims that a person has been fired simply for asserting that she may have legal rights? Second, how far does the principle of church autonomy or similar principles of non-interference with matters of church doctrine and obligation extend when you're not simply dealing with the selection of ministerial employees? Does it give a church the right not to be subject to something like the contraception mandate, assuming for the sake of argument that that is generally applicable law? Does it give a similar right to parachurch organizations like church hospitals? What about private for-profit companies whose owner insists, with or without good evidence, that his or her company should not be obligated to follow the mandate, even if non-religious employers are obliged to do so? Those are difficult questions, and I don't think it's just punting, maybe a little bit, but I don't think it's just punting to observe that these questions are properly subject to reasonable contestation and disagreement. I think it matters with respect to how we talk about these issues and how, especially those of us who do advocate for robust institutional autonomy, including church autonomy, how we talk about these things. To take a broader example, there's a famous free exercise clause case called Employment Division versus Smith. The Supreme Court in that case held that neutral, generally applicable laws that incidentally burden religion give rise to no free exercise claim. In those cases, legislatures may choose to accommodate religious obligations, but they are not obliged to, and courts are not obliged to accommodate. When that decision came down, many law and religion scholars viewed it as a horrible, horrible mistake. Over the years, however, many of them have become increasingly reconciled to it. My friend Rick, I think, is among them. I'm less reconciled to it, although certainly, given the way the decision has been interpreted, it's turned out to be much less disastrous than its critics predicted. But I think there's room for good faith disagreement here, and that arguments can be made that either arrangement is consistent, that is to say, accommodation by the courts or some kind of discretionary accommodation is consistent with a reasonable claim of justice. And that's also true with respect to arguments about the scope of church autonomy, its application, and its limits. Again, I do think a proper understanding of a full, just social order, one that's not focused on the state alone, suggests something like a principle of church autonomy and indeed of due regard for other key social institutions. It counsels at the least judicial deference, sometimes judicial abstention, sometimes something stronger, a recognition of institutional autonomy. But I think there's reasonable room for debate about precisely what justice requires, even under this vision. The third point I want to make is this. Even if it's true that church autonomy is part of a just social and legal order, it tells us very little about how churches under such a legal regime should behave. Now, that should be obvious. Sure, to this audience, it is obvious. But lawyers, at least, have a bad habit of sometimes thinking that questions of justice can be answered completely by answering questions of law. Less so, no doubt, at Notre Dame Law School, but certainly the habit is endemic elsewhere. Lawyers, including academic lawyers, who focus a good deal on judicial opinions can sometimes lose interest in matters that fall outside the four corners of that opinion. And it's even sometimes the case that non-lawyers in a heavily legalized society like the United States can sometimes associate justice too closely with what legal doctrine is or ought to be. So I think this banal point is still worth emphasizing. Now, as I said earlier, and I'm happy to plug a book twice if it results in 0.1% of additional sales, I have this book called First Amendment Institutions, and it argues that a variety of institutions, including churches, the press, universities, and others, play an important structural role in public discourse and the social order, and that the law should recognize and encourage that role by giving substantial legal autonomy to those groups within the sphere of their proper function. Part of the reason for that, in my view, is that these groups have a long tradition not only of expertise, but also of self-regulation in accordance with relevant institutional norms and functions. And for me, that also means that when we ask how these institutions are to be restrained or managed if the law is going to be mostly disabled from doing it, the answer is twofold. First, these institutions must engage in meaningful self-monitoring, self-criticism, and self-regulation. Second, they should be subject to meaningful public discussion and criticism. If these institutions are a key part of the whole social order and vital to public discourse for all of us, then it means everyone, and not just members of those institutions alone, has a duty, perhaps a duty, maybe that's putting it too strongly, but we should all care at least what they do and how they act, and we should engage with them. I don't think courts should be able to tell the Boy Scouts whom their leadership must consist of. I think they should defer to these organizations' own understanding of what their mission requires in this regard. But I do think that members of the public who disagree with the Scouts' position on its leadership are not only entitled to engage with and criticize the group, but even positively obliged to, even if the final decision must not rest with the courts and must ultimately rest with the institution itself. So I would say this about the ministerial exception, broader claims of church autonomy, and the relationship between the claims of law and the claims of justice. Now, the story does not end when the court stays its hand and says that even socially worthy public legal norms of non-discrimination must stand down where central internal church matters are concerned. Precisely because it enjoys legal autonomy in this area, it's all the more important for the church, any church, to monitor and regulate itself carefully and conscientiously with respect to such decisions. A church's decision to fire someone for reasons that look as if they relate to race or sex may be legally unreviewable, but that decision can still be unjust. Of course, churches themselves know this, and many of them are replete with all kinds of manners of fair processes, books of order, etc. But again, it's important for all of us to appreciate that real justice will lie in how they treat their own members and employees and how conscientious they are about monitoring and, where necessary, correcting their own behavior. And it is not illegitimate as such for members of the public to disagree with particular such decisions and criticize them. Now, my last point relates all this to current events. And I should say, I'm not a fan of the contraception mandate, at least in particular applications. I'm not here to defend it. I think some accommodations or exemptions are clearly required from that mandate as a matter of religious liberty and of constitutional law properly understood. Even under current legal doctrine, I think there are strong arguments against a mandate on the basis of the Religious Freedom Restoration Act. It's less clear to me precisely how far those accommodations must or should reach, either as a matter of law or justice, whether they should reach private employers, for instance. But I do think church autonomy is implicated by the mandate and demands some accommodation. But I think it's arguable, maybe even more than arguable, that the recent religious liberty campaign by the Catholic bishops, which foregrounded the contraception mandate, did not succeed terribly in persuading others of this point, which I share in common with them, or in convincing others that the failure to expand the existing accommodations in the mandate, which again I think were not wide enough, represented an existential threat to religious liberty. Now, my friend Rick has argued very powerfully and persuasively in an exchange we had online this week that the Fortnight for Freedom and related statements, whatever their efficacy, were important for purposes of witness, and I have absolutely no quarrel with that. But I want to suggest that this campaign was missing two aspects, both of them perfectly consistent with that witness function, and both of which might have made the campaign more persuasive, both within and beyond the fold. The first is a public emphasis on precisely the kinds of self-monitoring, self-regulation, and self-criticism that I've talked about. Certainly the church, like other institutions in society right now, operates in the context of a general erosion of trust in both public and private institutions. If you want to argue that churches or other institutions require legal autonomy, it will help at least if you can establish a strong foundation for the public belief that you're actively engaged in just and sound institutional self-regulation and reform. This need not, should not be a defensive exercise in my view, but it should be a public exercise, a trust-building exercise, and it can and should be linked in the end to precisely these questions of institutional legal autonomy. The second and final point is to recognize that even if particular church doctrines, such as positions on questions of life, are quite properly non-negotiable, and even if some aspects of church autonomy are a central part of both one's religious doctrines and one's view of the limits of the just state, even as I say, if both these things are true, there is inevitably going to be room for reasonable contestation, disagreement, and debate about the precise scope and mechanics of church autonomy as a matter of legal doctrine. And that, too, should be part of the discussion, including part of the very public advocacy by the church. It does not mean resiling from core commitments, but I think it does mean being open about which are the core commitments and which lie within the realm of reasonable disagreement. A local priest in Washington, D.C. wrote in the National Catholic Reporter this past week, and again, I'm not endorsing all of his views, bishops and Catholic publications used words like alarming, unprecedented, and unconscionable about the HHS mandate, but most people did not see it as an existential threat to our religious liberty. They saw it as a disagreement over government policy. Now, I don't quote this to take sides on it altogether. Rather, I'm talking about just how institutions argue, how they are morally bound to argue, and how they are likely to succeed in persuading. Something is right, I think, in what he says. Even those of us who agree, as I do, with the position of church autonomy, understand that how it applies and to whom it applies, whether it should be a matter of legislative grace or judicial mandate, are complex questions. And it is possible that the witnessing in this case would have been more successful, and I should say may yet be more successful because the fight is certainly not over, if those nuances and the scope of reasonable disagreement over them were clearly acknowledged. So for me, in closing, it comes down to this. Church autonomy is important. It is just. The autonomy of central institutions in our public order and the recognition that the state is neither the only nor the most important institution within our social infrastructure is a part of a just social order. But even those who believe firmly that this is so must recognize that we will necessarily face questions of scope and application as to which reasonable and reasonably just people may differ. And especially those who believe strongly in church autonomy or other forms of institutional autonomy must recognize the importance of conscientious self-regulation and self-criticism and public self-regulation and self-criticism, both because justice demands it and because it's a responsibility that necessarily accompanies having some scope of immunity from the operation of the law. I don't think acknowledging these things needs to be defensive or apologetic, but I do think it needs to be public, and that it will ultimately make the public case for church autonomy much stronger and more persuasive. Thank you.
Well, so this is the 13th of these fall conferences, and I think it's my 12th. And it is for me, as I'm sure it is for many of you, a real highlight of the academic year. And I'm reminded yet again of what a debt so many of us owe, certainly the university community owes, and I feel like I owe, to the center's founding director, David Solomon, whose vision for this enterprise has so enriched this place. And I think, reflecting on how this weekend's gone so far, under the new leadership of my colleague Carter Sneed, I think there's a whole lot of great times ahead. One of the great things about my gig is I get to read and learn from people like Professor Moreland and Professor Horwitz. One of the downsides about going after them on a panel is that all the really cool stuff I was going to say, they said. So I'm going to try to edit on the fly, but just rest assured that if there was anything really wise that either of them said, I had planned on saying it too. I'm just trying to avoid repeating it. So it's widely thought that there's a tension between claims of equal rights and claims of religious freedom, between the enterprise of promoting equality through anti-discrimination laws and the enterprise of vindicating religious freedom by, among other things, limiting the reach of such anti-discrimination laws. And this tension is real. It's also unavoidable and ineradicable because of here-to-stay and non-trivial disagreements among people of goodwill about the meaning and foundations of human equality, dignity, and freedom, and also about the appropriate aims and reach of government power. I'm going to suggest, though, that this tension might be lessened or at least better managed if citizens and lawmakers thought a bit more carefully about when and why discrimination, in scare quotes, is wrong, and also about the moral and constitutional limits on government's efforts to combat, in the name of equality, wrongful discrimination. And along the way, I will propose that what the Holy Father and others call healthy secularity provides a promising way of thinking about these matters. So questions about the relationship and the potential for conflict between liberty and equality are among the longest running and most difficult in political thought. These two ideals, as we all know, figured prominently in the rhetoric of the French Revolution, but as we also know, liberté and égalité fared better in rhetoric than in practice. Abraham Lincoln proclaimed that the United States was a nation conceived in liberty and dedicated to the proposition that all men are created equal. But he knew perfectly well then, as we do today, that not everyone enjoys liberty consistent with that proposition. The Constitution of the United States promises, indeed it requires, equal protection of the laws, and our commitment to equal justice under law is recorded in the stones of the Supreme Court building itself. A wide range of federal, state, and local laws complement this promise by forbidding discrimination on various grounds and in various contexts, including housing and employment and social services and so on. So the proposition that it is not only true, but in the words of the Declaration of Independence, self-evidently true, that all persons are created equal is foundational for us, as it is that we are endowed by our Creator with an unalienable right to liberty. As Kenneth Karst put it, a society devoted to the idea of equal citizenship will repudiate those inequalities that impose the stigma of caste and thus belie the principle that people are of equal ultimate worth. And the United States aspires to be such a society, and it aspires to act accordingly. However, on the other hand, the idea of a limited state in a free society is no less well pedigreed in our tradition, and it is, according to Michael McConnell, among the most foundational and fundamental features of liberal democratic order. And what's more, religious liberty, our first freedom, was central to the founding generation's vision for America. But this pride of place for religious liberty has not prevented conflict between it and, again, some understandings of equality. In the present day, an increasing number of incidents, debates, legal battles, and court decisions illustrate the tension between the desire and efforts of governments to combat invidious discrimination on the one hand, and on the other, the constitutional and other limits on these governments' power and ability to do so. We shouldn't expect this tension to resolve itself or to disappear. Perhaps, though, as I suggested earlier, it could be mitigated if we reflected more closely on the foundations of religious freedom and on the premises of the anti-discrimination project. So religious freedom, I believe, is foundational. Little that matters is secure if religious freedom is not. And as I see it, it's not merely the result of government's grace or concession or toleration. It instead has its foundations, as the Second Vatican Council put it, in the very dignity, we should note the equal dignity, of the human person. Religious liberty is not only a matter of right, it also corresponds to what Madison called the duty of every man to render to his Creator such homage and such only as he believes to be acceptable to him. This duty, Madison continued, is precedent, both in order of time and in degree of obligation to the claims of civil society. And it's precisely this precedence that religious freedom expresses and vindicates. That religious freedom is connected closely to bedrock truths about who and what we are doesn't mean that it cannot be abused, as Professor Horwitz said, or that it is absolute. After all, it's long been the case, it's always been the case, that legal protections for religious freedom in America have been shaped by a recognition that religiously motivated conduct can disturb, as some early state constitutions put it, the peace or safety of the public. We Americans were optimistic at the founding that our religious freedom commitment would, again in Madison's words, add luster to our country, but we didn't imagine that this commitment would be costless. In a similar vein, the Second Vatican Council's landmark Declaration on Religious Freedom acknowledged that this freedom is shaped and bounded by considerations of, quote, the rights of others and the, quote, just demands of public order. The right to religious freedom, the Declaration teaches, is, quote, exercised in human society, hence its exercise is subject to certain regulatory norms, and in the exercise of their rights, individual men and social groups are bound by the moral law to have respect both for the rights of others and for their own duties toward others and for the common welfare of all. So this fundamental right is not denigrated by the Declaration's recognition that society has the right and duty to defend itself against possible abuses of that freedom in order to secure, quote, a genuine public peace. So there is not a tension in principle between a commitment to the fundamental right of religious liberty on the one hand and an appreciation for the fact that political communities may and should use regulatory and other powers to promote the common good, to protect the rights of others, and to secure the public order. The challenge, of course, for communities is to identify accurately the content of the common good, the contours of others' rights, and the demands of public order. So what then about the ideal of equality and the anti-discrimination laws that aim to vindicate it? Well, for starters, discrimination is wrong. And because discrimination is wrong, we think, governments like ours, secular, liberal, constitutional governments, may and should take regulatory and other steps to prevent it, to discourage it, to denounce it. And we're right to believe these things. We're right to believe that equality-vindicating anti-discrimination laws, if they're crafted and enforced well, can, in the Declaration's words, promote the common good, protect the rights of others, and secure the public order. But at the same time, it is not true that discrimination is always or necessarily wrong. Nor is it the case that governments always or necessarily should or may regulate or discourage it, even when it is. After all, discrimination is just another word for decision-making, for choosing and acting in accord with or with reference to particular criteria. We discriminate all the time. No one thinks it's wrong to prefer Brunello to Boone's Farm, and however much some of us who root for Notre Dame might resent it, we don't think Nick Saban is engaging in wrongful discrimination when he seems to discriminate against people with merely human football talents. As Professor Larry Alexander once put it, all of us well-socialized Westerners know that discrimination against other human beings is wrong. Yet we also realize, if we think about it at all, that we discriminate against others routinely and inevitably. So this is, I realize, an obvious point, but I think it's worth making. It is not discrimination that is wrong, it is wrongful discrimination that is wrong. And it is tempting and common, but also misleading and distracting, to attach the rhetorically, the morally powerful label of discrimination to decisions and conduct whose wrongfulness has not yet been established. After all, there is no good reason to ban or to regulate or to disapprove of discrimination generally, as opposed to discrimination that has been shown, with reference to factors other than the mere use of criteria, to be wrong. In addition, we for good reasons do not believe that governments should or may prevent, correct, or even discourage every instance of wrongful discrimination. Some wrongs, some bad conduct, again, as Professor Horwitz explained, are beyond the authorized reach of government policy. Some are too difficult or costly to identify, let alone regulate. Others are, put simply, none of the government's business. What's more, it's not only that over-enthusiastic or insufficiently deliberate campaigns against discrimination in the name of equality can conflict with the fundamental and core idea of limited government. There's also the need for an appropriate humility about our ability to identify with confidence the content of our ideal of equality. One does not have to insist that the, quote, idea of equality is empty, as Peter Weston put it, to admit that it is reasonably contested, and it's more easily admired than implemented. So again, when we say discrimination is wrong, what we actually mean is that wrongful discrimination is wrong. And when we affirm that government should oppose it, we mean that government should oppose it when it makes sense, all things considered, and when it is within their constitutional power to do so. To label a decision or an action discrimination is simply to note that one factor or another was or will be taken into account in the course of a decision. That label invites, but it doesn't answer questions whether that decision or action was or would be wrong, and whether the public authority may or should forbid or discourage it. Answering these questions requires careful consideration of a wide range of factors and variables. Who is the decision maker? Who are the affected parties? What is the criterion for decision? How will the decision and others like it affect our ability to respect and vindicate other goods? How costly would it be to try to regulate or prohibit such decisions? Is the social meaning of the particular decision in question such that it, in fact, quote, belies the principle that people are of equal ultimate worth? Or is it something else? And is the decision one that a limited state in a free society has the authority to supervise? In other words, and as usual, context matters. It's not enough merely to report the occurrence of discrimination or to invoke the ideal of equality and to assert its, quote, primacy, or to declare, as the Supreme Court often does, that particular decisions are invidious or odious or suspect. These terms communicate something important and troubling about some instances of discrimination. But the point is, those terms add something to what they modify. So circle back now to religious liberty and its connection to anti-discrimination legislation. It is not contrary, I suggested, to a commitment to religious freedom, indeed it's part of such a commitment, to say that governments may use their police and other powers to prevent certain wrongs. Discrimination can be, but is not necessarily, such a wrong. And so the important enterprise of respecting and protecting religious freedom is closely related to the also important enterprise of using public power to regulate and discourage wrongful discrimination. We care about wrongful discrimination, and so we care about wrongful discrimination by religious actors. We care about wrongful discrimination for religious reasons or along religious lines. And we think that some kind of a connection between discrimination and religion often does make that discrimination wrongful. At the same time, discrimination on religious and other grounds can also be a dimension of religious liberty, the liberty that governments may and perhaps even must accommodate. Sometimes a government like ours should regulate discrimination that targets religious status or is motivated by religious belief or is engaged in by religious actors. But sometimes a government like ours may, will, and should protect or at least leave alone such discrimination. Sometimes it is wrong in a way that implicates the concerns of a liberal constitutional government for religious communities and actors to discriminate, but sometimes it isn't. In the former type of case, such a government will want to respond in some way, and so long as it is within its authority and not too costly to do so, it probably should. But in the latter type of case, such a government, again, a liberal constitutional government, should be unbothered, or at least unmoved. So as we engage and we try to manage this tension between religious freedom on the one hand and anti-discrimination law on the other, we need to be sensitive to the fact that the rhetorical and moral and legal power of the anti-discrimination norm can sometimes distort or distract our thinking about how to protect religious freedom through law. This is because the very common, if sometimes unreflective, conviction that, quote, discrimination is wrong means that assertions of religious freedom are sometimes heard as requests that the political authorities tolerate a wrong, i.e. discrimination, a wrong that they would otherwise want to prohibit or penalize or discourage. And then such requests are thought to raise the question, is it worth it for the authorities to do so, to tolerate this wrong? Would it complicate too much the government's own projects or conflict too glaringly with the government's own values? And so, when they are granted, religious accommodations are often regarded as concessions. And sometimes, to be sure, we do, and we probably should think about legal rights as protecting or tolerating a liberty to do even the wrong thing. But we shouldn't forget that a dimension of the freedom of religion is sometimes precisely the freedom to discriminate, and that this freedom should not be protected simply because such discrimination is, all things considered, tolerable. Sometimes it is, sometimes it isn't. But because it is inextricably linked to a human right and sometimes beyond the political authorities' legitimate reach. Now, in the paper, I now have several pages of brilliant exposition of a number of Supreme Court cases, each of which raises the question when and why discrimination is wrong. And if you want to hear more about that, I'd be happy to give you a copy of the paper. So why is discrimination wrong when it is wrong? Well, we believe that discrimination is wrong, but we're not always sure what makes it wrong. It's probably not the case that discrimination's wrongfulness comes down to the presence or absence of any one thing. Deborah Hellman has argued that harm to a particular person subject to discrimination is neither necessary nor sufficient to establish that discrimination is wrong, and that the better question is to ask whether a certain distinction demeans or denies the equal moral worth of the person who's being affected. And my colleague Robert Rhodes has insisted the fact that people are of equal ultimate worth is and must be relevant to the legal enterprise. Now, I believe that discrimination is wrong when it is wrong for pretty much the same reason that religious liberty is a fundamental human right. That is, because every person is made in the image of and loved by God, and as a consequence bears a dignity that ought not to be violated. And this is as true for all of us as it is for some of us, and it shapes and constrains both how we may and may not treat each other and how governments ought and ought not to treat us. Discrimination is wrong when it denies the equal dignity of every person, but again, sometimes it does this and sometimes it doesn't. Whether it does or does not depends. Now, I noted at the outset that what Pope Benedict XVI and others call positive or healthy secularity could provide a promising, pluralism-respecting way of thinking about this tension between equality claims on the one hand and religious liberty claims on the other. During his 2008 visit to the United States, the Pope praised America's, quote, positive concept of secularism, in which government respects both the role of religious arguments and commitments in the public square and the important distinction between religious and political authority. For present purposes, though, what's most noteworthy about the healthy secularity model is that it is pluralistic and it's constitutionalist. It's pluralistic, first, in that it accepts as given the fact that reasonable people, associations, institutions, and communities disagree reasonably about things that matter. This side of heaven, we and our governments do well to resign ourselves comfortably to the crooked timber of free society. And governments should acknowledge and accept their limited competence to resolve authoritatively these disagreements. But the healthy secularity model is pluralistic in another sense. 6 decades ago, the great church-state scholar Mark DeWolf Howe identified the, quote, heart of the pluralistic thesis. It is the conviction that government must recognize that it is not the sole possessor of sovereignty, and that private groups within the community are entitled to lead their own free lives and exercise within the area of their competence and authority so effective as to justify labeling it a sovereign authority. To make this assertion is to suggest that private groups have liberties similar to those of individuals, and that those liberties, as such, are to be secured by law from governmental infringement. Our evaluation of the practices and policies, the discriminatory practices and policies, of intermediate associations and non-state institutions should be informed by this pluralistic thesis. These institutions, after all, transmit values and loyalties to us. They play what Professor Horwitz and I have both called an infrastructural role. They mediate between persons and the state. Our Constitution, I believe, should be understood, consistent with this idea of healthy secularity, as limiting the power of government to standardize belief by commandeering this transmission. Diverse non-state institutions can be seen as the hedgerows of civil society, as wrenches in the works of whatever hegemonizing ambitions governments might be tempted to indulge. Now, healthy secularity is also constitutionalist. Constitutionalism, among other things, is the project of protecting human freedom and promoting the common good by categorizing, separating, structuring, and limiting power in entrenched and enforceable ways. And we had a great panel on this topic here yesterday afternoon. The American Constitution provides a first-rate example. As every law student learns, or should, those who designed and ratified the Constitution believed that political liberties are best served through competition and cooperation among plural authorities and jurisdictions, and through structures and mechanisms that check, diffuse, and divide power. The Constitution is more than a catalog of rights, in other words. Our constitutional law is the law governing the structure of and the allocation of authority among the institutions of the national government. So these structural devices include ones like the separation of powers, judicial review, and federalism, but they also include the protections that our Constitution provides to these mediating non-state institutions. With respect to religious institutions, the point is even stronger. As the court appreciated in the Hosanna Tabor case, the deference afforded to churches in the selection of ministers, teachers, teachings, and doctrines is not the result of a balancing of interests. Instead, it's about history, first principles, jurisdiction, and power. It is true that the lines separating internal church matters over which they have autonomy from the many activities that can be regulated, the line won't be clear or easy to locate, but that's nothing new in the law. A healthy, positive separation of church and state, correctly understood, is, like the separation of powers, like federalism, a structural device that protects human freedom. It's an arrangement in which the institutions of religion are distinct from and independent of government. It's a principle of pluralism, of multiple authorities, of competing loyalties. And it's a rule that limits the state and thereby clears out and protects a social space within which persons are formed and educated, and without which religious liberty, which is to say equal religious liberty, is vulnerable. Thanks.
Thanks to each of our great panelists. We are technically at our limit, but our next activity is not lunch, so we have time for questions. If you would approach the microphones and, according to our usual custom, identify yourself and the speaker whom you would like to address your question. Go ahead.
Melissa Muscala from Princeton University. So thanks for all of those very insightful presentations. I was thinking about what you were saying in light of the HHS mandate, and in light of the fact that a large part of the problem, I think many of your presentations focused on the problem of institutional autonomy of the church. But then, of course, there's the other half of the problem, which is the individual conscience rights of believers. So, for instance, the non-religious organizations and the rights of the business owners there, or even the rights of insurers or private people who want the option to buy insurance that doesn't include those services. And so I was wondering there if there is a reason, a religious liberty-based reason, to try to avoid overreaching sort of government intrusion in terms of defining things like what counts as health care, or, you know, in other words, is a very strong welfare state because of the extent to which it involves the government regulating at a very micro level a lot of decisions that are inevitably going to enter into difficult moral and religious questions. Is that in and of itself something that threatens religious liberty, such that we should be concerned? Does that give another reason for a more limited sort of government in terms of its intervention and regulation into the private sphere?
So first of all, yes, I think it is relevant. And certainly, I think kind of a common theme for students of law and religion is that one reason we face so many difficult conflicts is because the reach of the regulatory state has expanded dramatically. Now, I think I'd say two things about that. Part of that is that we also may have a more complex or socially integrated view of what constitutes the public good and how to best achieve it. So I think some of these present genuinely difficult questions, and alas, we will fall back a good deal on interest balancing. And the second thing is to say, and this is relating to this point, that there are kind of two ways to think about what we do. One is to have a limited state, and the other is to have more of a public state. That is to say that sometimes it's precisely all these public-private partnerships or using existing private institutions as a vehicle for carrying through public policy that can end up trenching on the consciences of those individuals, right? So it may be that there are other problems with this and debates over public policy, but sometimes it's not a question of a bigger or smaller state, but of who ought to be carrying out these public policies, and whether sometimes it's almost less intrusive on conscience to have a large state do it than to push it down to various private actors.
I mean, I agree with much of that, I think, but I do take your point, Melissa, that the definitional enterprise itself that is often at stake in these debates can often be a problem. So I, for instance, several weeks ago gave some testimony in a House committee on the issue of NLRB jurisdiction over Catholic universities. And the underlying issue, of course, is unionization, on which I tried carefully not to take a position on, on the merits one way or the other. The problem is that the NLRB is going around combing through the theology requirements and the frequency of mass attendance of students at Catholic universities. And I think that itself is a problem, and touches on many of the themes that both Paul and Rick have talked about with regard to institutional competency and legitimacy of the government. And so I think you're right that it's the very active definition and assertion of jurisdiction that itself can raise these problems.
My name is Angela Michelli. I'm a PhD student from Louisiana State University. And this question is mostly for Professors Horwitz and Garnett, but the whole panel. Professor Horwitz, you mentioned at the beginning that a just social order needs to recognize a central role for these outside institutions, but that this can be contested and we can have reasonable debate. And Professor Garnett, you mentioned disagreeing reasonably. And my question is that it seems to me that our public discourse, particularly about these more religious liberty issues like the HHS mandate and the marriage question, that these are really anything but reasonable. And if reason is ever really introduced into the matter, it's usually a very truncated rationalization, maybe. So I guess my question is, it's kind of a big question, what is reason's role and what should it be capable of in disagreeing reasonably?
That's an easy one.
Well, I think as Professor Horwitz pointed out, we're legal academics, and so our job is to be banal and not profound. I will say this, so you're right. I mean, in its colloquial sense, reasonable would not seem to be an apt descriptor for the way a lot of our public policy debates are conducted. I'm a little spoiled. In the Law and Religion Guild, even the folks with whom I disagree pretty profoundly actually do conduct themselves, I think, civilly, reasonably, and I kind of see the moves they're making, and they see the moves I'm making, and we acknowledge what each other's different premises are, and if you identify fundamentally incompatible first principles, and you're not surprised if you end up with incompatible applications of those principles. I don't pretend for a second that the way these things play out in public mirrors the kind of tone of the dialogue that I get to participate in. I wish it did. This is not a good answer to your question, but it's all I can think of.
I'll say one. I mean, first of all, those of us who kind of write about the religion and politics issue, there's kind of the pall of the seminar room over what we do, right? We kind of hope that it'll all look like the best seminars we had at university, and we know that public discussion is often far different than that. So I am a little skeptical. I actually don't even think that we ought to suppose that those discussions be conducted like university seminars. There's room also for passion and forthrightness, and it'll be there regardless. I do think we're maybe more productive, kind of going along Rick's lines, if we try to figure out what our non-negotiable points are. I think there's nothing wrong with standoffs on values where people simply cannot cross lines, but it's important to identify precisely where those lines are so that we can distinguish between those things on which there may be no possible further productive discussion and those things about which there actually is room for civil debate.
Hello, thank you all for speaking today. My name is Paul Baumgartner, and I'm from the University of Michigan. And my question is most directed to Professor Garnett, although I'd love to hear all three of yours take on this matter. Recent comparative constitutional research has showed that both new and old democratic states are tending to move away from the American constitutional model when drafting or redrafting their own constitution. And I think nowhere is this more evident than on issues of religion. Currently, new constitutions have 95% of new constitutions have codified what amounts to a free exercise of religion clause, whereas less than 1/3 of new constitutions have codified something that amounts to an establishment clause. So, Dr. Garnett, I was wondering whether or not you could discuss the extent to which you believe the establishment clause is necessary in the American constitutional model for protecting against what you deem to be wrongful discrimination or coercion, and whether or not you think that this international trend away from the Establishment Clause actually makes the distinction you were making between wrongful discrimination and discrimination.
Yeah, I'll try. I should say first, just full disclosure, I don't deserve the title doctor because, again, I'm just a lawyer. But so to start on your point about establishment.
First, doctor.
I don't think that a non-establishment rule is essential for the freedom of religion. As John Courtney Murray and many others since pointed out, you know, the Declaration on Religious Freedom was open to the possibility that you could have church-state arrangements where there was some of what John Adams called, you know, a mild and equitable establishment. The concern was that you'd have coercion. In the American experience, I happen to think, this might be kind of Pollyannish, that the No Establishment Clause, put in bold, properly understood, serves well religious freedom because it does facilitate what the Pope calls this healthy secularity, which is not a naked public square, but rather a distinction between political and religious authority. So where we went wrong, I think, in some of our understandings of the Establishment Clause was in confusing the church-state question with the religion and public question. If you limit the Establishment Clause question to protecting religious authorities from, you know, murder in the cathedral type impositions, then I think the No Establishment Clause is a pretty good one. So the fact that it's not being mimicked in some of the newer constitutions doesn't really surprise me, and it doesn't necessarily even trouble me, so long as the omission of a non-establishment clause is accompanied by a meaningful commitment to freedom of religious exercise and to non-coercion and non-discrimination.
I'd say that in other constitutional states, the non-discrimination norm is going to do potentially a lot of the work that the Establishment Clause does here. And I'd also say that some of those states may have decided, more or less, that the approach they've taken is conducive to religious peace, especially given the kind of demographics and the history of established churches there. I tend to be pretty bullish on the Establishment Clause, and I think that one of the reasons is that it provides for substantial religious diversity or contributes to substantial religious diversity. So perhaps two different goals in a sense.
Our final question.
I very much enjoyed the panel. I'm going to pick up on a remark that you made, Professor Horwitz, about the Fortnight for Freedom. I suspect the bishops couldn't have won. And the reason is the dominant secular culture is so powerful. There are two different paradigms, and the ability to talk to people in the other paradigm is very incumbent. We don't have one notion of moral rationality. 47% of all kids are being born out of marriage. And you're going to explain to those people about how important the commitment to avoiding contraception and hospitals. I don't think they'll come close. Increasingly, traditional Christians, Orthodox Jews, traditional Mohammedans will look just terrible because we are...
Ladies and gentlemen, may I have your attention, please?
And heterosexist.
Lunch is now being served at the lower level. If you'll please make your way down there now.
And therefore, picking up Professor Moreland, That's why Rawls, in his 1997 Law Review article, is quite happy for the state to interfere in the family and the education of children, saying that there's no right to privacy there. So I wanted to just end with a little barb against John Rawls.
Always appropriate.
Thanks again to our panelists.